the proceedings are still on. That is a fact, well known to everybody. Third, Mr. Speaker, sir, on the civil proceedings, it shall be deemed to be active when arrangements for hearing, such as setting down a case for trial, having been made, until the proceedings are ended by judgment or discontinues. Today, before I came to this honorable house, were before the Court of Appeal. A judgment or a ruling is coming out on Friday over the same issues that are before this honorable house. Do we close our eyes? The governor has been charged for contravention of the law. The governor's allegation are an allegation of abuse of the Constitution. The governor's allegation against her are based on law. Do we ourselves close our ears from following the law? And we say we must defend the law against the governor, but the law cannot be enforced against us. Members of the County Assembly, that is the question before the Speaker and before you. Number D, appellate proceedings like the one we were today, whether criminal or civil, shall be deemed to be active from the time when they are commenced by an application for leave to appeal or by notice of appeal until the proceedings are ended by judgment or discontinues. The law, as you passed it, says an appellate appeal either from a magistrate's court or from a high court to the Court of Appeal, or from a Court of Appeal to the Supreme Court, binds this assembly. Now the burden on the governor is on number 4. That whoever alleges, a member alleging that a matter is sub judice, shall provide evidence to show that paragraph 2 and 3 are applicable. We shall table all the cases that are alive in court, and those cases are touching all the 7 counts that the governor is facing. That in itself, in the question of law, is a preliminary objection on the question of law. Once that question is determined, I'll pack to leave to Nyamira, or I'll continue with this submission. Because if a question of law has been raised, a preliminary objection of law, that these proceedings, there is no jurisdiction to entertain this matter. Because the matters are active in a court of law. Then we reconstitute ourselves and close our ears and close our eyes and see a good case you have against the governor being thrown out at technicalities. Reconsider and let the matters be determined, that those matters that are in the High Court, let those matters in the Magistrates' Courts be determined, let those matters in the Court of Appeal be determined, bring a proper motion, remove your governor, because that is your right. It cannot be taken taken away by anybody. It is protected by 55 million Kenyans who passed the constitution on the 27th of August 2010. It goes further and says in paragraph 5, notwithstanding the standing order, the Speaker may allow reference to a matter before the House or a committee. The Speaker can only have a reference or a citation. So the question I'm pushing ahead, and my colleagues are pushing, is how did this motion of impeachment pass the threshold for it to be in the order paper as a subject of discussion? It was an error, and we simply agree that that error is not fatal. We would stop this matter until when the law allows you to remove the governor. It is your right. I'm telling you, it is your right. Some of the matters my good friend Mutuma will raise are filed by the assembly. Can we move one step further? Second question. The question about public participation. A report has been tabled. A report has been tabled. When you look at the standing order 68, look at it. Standing order 68. It says the accused person needs to be given at least, and it is shall, 2 hours to read, to update herself, to instruct his counsels on what to answer. That report is only known to others, not to the person accused person. Is that the order that we need to be given that report? Look at it, at least 2 hours. We take instructions from the governor. We respond appropriately. Third issue on question of law. What does the law say on where public participation is supposed